To you.
Thank you very much indeed. It's a pleasure to be here and an honor to be introducing this seminar, which I'm sure I will learn as much as anyone else here, and therefore I will not take up a great deal of your time. Artificial intelligence is a relatively new to most of us and relatively frightening to many of us development. But we have to remember, so far as frighteningness is concerned, that we quickly adapt to what appears to be new. The idea of each of us having our own mobile phone, the idea of each of us having a laptop, the idea that anyone could search the internet for any case they wanted to see any information they wanted 30 years ago would have been pretty strange to many of us, and 50 years ago, very strange to anybody. And yet not merely have we adapted remarkably quickly, but we can also see that these extraordinary developments have downsides as well as upsides. The downsides, of course, are in terms of shortness of attention, fake news, the dark web, pornography, and gambling and worse on that is made freely available to everybody and is in practice very difficult, some might say impossible to control. AI, as it develops, also has enormous potential for benefit and enormous ability, no doubt, to disrupt and do worse than disrupt. We were discussing earlier, for instance, the malign effect of US sanctions in terms of almost all IT companies being ultimately large IT companies involved with the internet and mobile connections and so on, being US controlled, and the effect of US sanctions on people who many of us would have thought were not merely innocent, but were positively doing good. And for the first time in this country, with the effect of what may be Russian hackers and what are US sanctions, we're beginning to realize how exposed we are, having previously maybe thought that it was other countries which were involved, of concern to us, but not direct concern. More specifically, in relation to the law, we've already seen the enormous influence of AI. Many lawyers, practicing lawyers, tell me that, for instance, if they have to prepare a document, be it a briefing note, a report, even a pleading, even a skeleton argument, they may invite AI to do the first draft. The implications of this, given that AI is at such an early stage, are fairly staggering, because in many cases they say that, of course, as we all know, AI is unreliable. Indeed, more than unreliable, it actually invents things that don't exist. Nonetheless, the document which it produces is often useful as a first draft, and often even experienced lawyers will say it contains ideas and points, even authorities, that they didn't know about. Sometimes those authorities even exist. So we are at an early stage, but the courts and judges have been very ready, and quite rightly ready, to warn lawyers against the use of AI, while not very sensibly suggesting it should never be used. Although I know from what I hear that some firms, when given instructions by a client, are positively told they shouldn't use AI, partly for reasons of confidentiality and partly for reasons of reliability. So as I see it, there are two main species of problem with AI and the law. One is, what do we do now and for the short term in terms of making the best use of AI while at the same time protecting ourselves against its misuse and its dangers? And secondly, what are the long-term implications of AI in terms of the law, the legal profession, judging, and dispute resolution? Today, no doubt, we will hear quite a lot about the first aspect, the immediate aspect, the aspect of immediate concern, and we may also hear more about the future. But for my part, as I said at the beginning, I will listen to what this experienced and diverse panel has to say on this interesting and important topic. Thank you very much indeed.
Thank you, David, and Jan, for your invaluable support. And thank you, David, for thought-provoking introduction. We appreciate your expert and advisory contribution to the project on the dynamics of judiciary in Ukraine, which I'm leading. And on this inspiring note, I'm pleased to open the discussion and introduce our distinguished speakers in the order in which they will take the floor. So our panel includes 4 distinguished speakers, and on my left, I am glad to introduce Dr. Serhiy Kozyakov, legal researcher, a leading Ukrainian expert who has led judicial reforms and pioneered innovations in the judiciary and legal practice in Ukraine. He was a member of CPEJ at the time of the groundbreaking 2018 charter on AI in judicial systems, and from 2014 to 2019, he was chairman of the High Qualification Commission of Judges of Ukraine. He is a visiting fellow with the London School of Economics and Political Science, and currently he is engaged in the Beqiraj project on the dynamics of the judiciary in Ukraine in the context of the rule of law and the European Union Accession Aspirations, and research of judicial reforms in Ukraine and the regulation of artificial intelligence. On my left as well, our colleague from UCL, Dr. Michael Veal. He is an associate professor and the vice dean for education innovation in the Faculty of Laws at UCL. His expertise intersects computer science and information law, addressing issues of fundamental rights in the context of advanced data analysis, machine learning, artificial intelligence, and encrypted computation. In 2024, Dr. Veal served as program chair for the Association for Computing Machinery Conference on Fairness, Accountability, and Transparency, and was the general chair of Hot Topics in Privacy Enhancing Technologies from 2020 to 2021. He also participates in a variety of program committees. We have one speaker online, and very glad that you can join us, Marek. Professor Marek Szwardziński, Vice Dean of the Law Faculty on the Cardinal Stefan Wyszyński University in Warsaw. He has established a research team at the Institute of Law Science and within the framework of the Virtual Department of Law and Ethics, focusing on expanding digital competencies in the field of artificial intelligence law. He has published monographs aimed at educating lawyers in the area of current artificial intelligence legal issues. He is the Council of Europe expert since 2016, member of the CPEJ Advisory Board on artificial intelligence, where he contributes expert insight on the application of AI within the judicial sector. And on my right, Judge Alexandra Janowska from Ukraine Supreme Court and current member of CPEJ. Alexandra has served as a judge of the Cassation Criminal Court of the Supreme Court in Ukraine since November 2017, From 2017 to 2020, she was a judge of the Grand Chamber of the Supreme Court. She holds a doctorate degree in criminal law and has taught at Kyiv Taras Shevchenko National University in Ukraine, where she became a professor in 2014. Judge Yanovska has served as an ad hoc judge at the European Court of Human Rights since 2015 and has represented Ukraine in the European Commission for the Efficiency of Justice of the Council of Europe since 2022. We are very happy to have such a brilliant panel with impressive and relevant background and expertise on the topic of today's discussion. And the way we are suggesting to proceed is that I'm going to get the ball rolling by asking the questions to our panelists. It should take up to 1 hour. And then we aim to save 15-20 minutes at the end for Q&A session with our audience. So we will begin our discussion with general questions when move to specific ones. And let me ask my first question to our first speaker. As far as we discuss the CPEJ standards, which cover the pan-European legal area, including the UK in broader sense, it is interesting to understand how Europe compares to AI world leaders, especially considering the ambition to lead the global AI race through strategic investments and partnerships. Recent speeches by the President of the European Commission have highlighted this ambition. So, Serhiy, could you please provide us with a brief comparative analysis?
Thank you so much, Tetyana. I belong to those people who do not have much trust in announcements of politicians. However, in my view, this statement does not seem populist. I suggest you take her seriously. Why is that? Because the topic of the AI race is significant, and artificial intelligence can transform the world every few months, not even every few years or 1 year. So it's necessary to speak very shortly about investments, about patents, and about notable models which main AI organizations created. If to speak about investments, I should mention that in 2024, United States companies, its own private investors, sold approximately $110 billion US, 20 times more than China, and 24 times more than United Kingdom. United Kingdom invested 4.5 billion. If to speak about more long period of time, from 2013, the country's rankings have remained consistent. The United States invested 471 billion. China invested 120 billion, almost 120, and the United Kingdom invested 28.2 billion. I do not mention any other countries because they invested much less. What about patents? China is #1 in the world, and they're representing almost 70% of all grants in patents procedure. Notable models. The situation is even much better for United States. In 2024, institutions based in the United States produced 40 notable AI models. China, 15, and Europe, all Europe, 3. But it's not all Europe, it's only France. If to speak about last 10 years, from 2014, number of notable AI models developed by 15 leading organizations from some countries. Total 542. United States, Google, Meta, Microsoft, OpenAI are the first four. They made 67%. If this put to speak about all American companies in this 15, there are 11 American companies. They made 88.2%. China, from this more than 500, China made 36 and United Kingdom 28. General conclusion from this very short description. The data indicate that Europe lags behind other regions in three key areas of AI development: the creation of notable models, patenting of inventions, and scientific, by the way, publications, as well as the volume of investment, including those in startups. The situation is, in my understanding, is even worse because what is happening during our using of AI tools is happening in a cloud infrastructure. What is happening in cloud infrastructure? In the end of April, I gave instruction to my students to make research in report of Competition and Markets Authority from United Kingdom, which is investigating the supply of public cloud infrastructure services in the United Kingdom. According to the report from the 28th of January 2025, the CMA provisionally found that UK cloud services market is highly concentrated. Amazon and Microsoft have on the UK market between 80 and 90% of economic power in the sphere of cloud infrastructure. And there are also three other American companies: Google, Oracle, and IBM. In this 10, maybe some percentage is UK belongs to UK companies. General conclusion today: it appears that technological oligarchs will wield not only economic power, but by monopolizing the production of rapidly evolving artificial intelligence tools, cloud infrastructure, and the producing of chips also, but also political influence in the United States. And we know about it. If to speak about producing chips, 99% belongs to the NVIDIA and also American company. 99%. I hope I did not scare you too much for this moment.
Not yet. Okay, thank you. Thank you for the statistics, impressive, and thank you for informative answer. And turning our discussion and focus it on judiciary, in your recent blog, Can Artificial Intelligence and Virtual Reality Become Part of the Judicial Reform in Ukraine? You divided all judges into several groups, depending on their attitude toward AI in the courts. So in your opinion, what are the most common judges' fears and biases? Briefly.
When I will give you my opinion, every time I will remind about Ukrainian judges who works during the war, in the situation of the full-scale war, and in the situation of judicial reforms which lasted for more than 10 years. In many countries of the world, judicial reform often becomes the subject of aggressive political battles and even becomes a factor of political crisis. In Europe, signs of this situation can be seen in Poland, Hungary, Slovakia, Italy, and Spain. In last month, we have seen this in Israel and Mexico. In Ukraine, since 2013, judicial reform has frequently been not only a factor of the political crisis, but also part of the ongoing polycrisis, which affects all citizens of the country and judges in particular. It impacts their mental health and well-being, unfortunately. Therefore, the first news about impact of the AI on the judicial process in other countries did not cause enthusiasm among judges in Ukraine. Rather, it caused wariness and even fear. Those who know nothing, there are some kinds of judges in their relationship to AI. And first group is those judges who know nothing about AI, except they have heard the words artificial intelligence, and they even unreasonably afraid of it because it may somebody replace a judge. I am sure that you have read a lot of information that AI, the results of using of AI will be that a lot of professions will disappear. And a lot of professions in the legal sphere, in the sphere of law, in the sphere of law. Judges think that they will be the first among many judges. Yesterday, I called to 10 judges in Ukraine during weekend and asked them if they are afraid of AI, using AI in judiciary. 50%, 5 of them told that I am afraid. 5 of them told them I do not afraid, without any explanation. I did not press him. And some of these judges read fake news that a robot judge has been introduced in Estonia. I read this information. I was astonished that Estonia made such kind of AI. And then I read, in a year and a half, I read the information from Ministry of Justice, which told that it's fake news. It was more than 1 year ago. But still now, I see some articles or blogs of lawyers who mentioned this fake news in Ukraine. So judges read it and afraid. Another group, those judges who have not only heard but also tried to use new fashionable generative AI tools such as ChatGPT, Copilot, and others. At home, they plan someday weekend, someday working week or weekend, or ask anything, and it's good in my understanding. And the fourth group is those judges who actively try to contribute to implementing AI developments in professional life. Who and what they do. Our National School of Judges of Ukraine also is introduced training for judges and assistant judges. It's kind of court clerks, judges on various aspects of AI. For example, the latest webinar held in April was attended by approximately 400 judges and their secretaries or assistants. It was another webinar for judges from the High Anti-Corruption Court. We have a high specialized court, High Anti-Corruption Court, and another webinar. Early in December, the head of the Supreme Anti-Corruption Court, or a chairman or president of High Anti-Corruption Court, signed an order on the principle of use artificial intelligence tools in this court. The chairman of the president of the Supreme Court and the chairman of High Council of Justice for the last 2 years in many of their speeches covered the topic of the artificial intelligence in justice. Our Congress of Judges also adopted a decision for mentioning of artificial intelligence in the Code of Judges' Ethics. It was a very important step in my understanding to solve these problems. And I think that there is also a problem, not only Ukrainian judges, but the judges in other countries, including UK. Today in the morning, I read information from the 4th of June. It was an information of British Office of Associated Press from London, and it was as follows. I read. A judge has stated that lawyers have cited fake cases generated by artificial intelligence in court proceedings in England, warning that attorneys could face prosecution if they fail to verify the accuracy of their research. High Court Justice Victoria Sharp remarked that the misuse of AI has serious implications for the administration of justice and public confidence in the justice system. I was shocked when I read another phrase on the one. In the ruling written by Sharp, the judge stated that in a 90 million pounds lawsuit concerning an alleged breach of a financial agreement involving the Qatar National Bank, a lawyer referenced 18 cases they did not exist. I am sure that British and Ukrainian judges will quickly overcome this concern.
Thank you, Sergey, and thank you for mentioning the UK, because our next speaker, Dr. Michael will address the perspective on the topic of discussion, the UK perspective. So I would like to ask you, the UK, along with Ukraine and other 14 other parties, signed the Council of Europe Convention, Framework Convention on Artificial Intelligence, Human Rights, Democracy and the Rule of Law. What is your perspective on the advancement of the UK judiciary on using AI tools?
Thanks a lot. So I think there's a couple of things going on there. I'm not an empirical expert on different judges using tools right now, but I also don't think you have to zoom out a little bit to see where is there space for interesting uses of AI in this, and where do we have to be aware and wary, and what are some of the risks on the horizon. And we have to think in quite, I think, a sophisticated and complex way to do this. So the best use for all these tools is just to grease the wheels of the general justice system, to let computers do what computers do best. People have always been sitting down, copying and pasting things from one spreadsheet or document to another, or trying to grapple with numbering formatting in Word or something terrible like this. Everyone's suffered through all of this kind of, why is this not working? Why is it not making any sense? AI can help people with some of these things, these very boring tasks, because computers are really powerful at doing things that can be automated at scale, but we don't all know or have the training or indeed the time to express to the computer and to know how to express, computer, please do this boring, repetitive task for me. So anything that helps us bridge that gap is great. These are similar things we can say with more advanced spell check and grammar check. Can you spot a missing word or a trailing sentence or something, so I can flag it and look myself with my own eyes? Can I do it immediately, so I don't need to wait for a copy editor or an assistant to go and look at this document as well? All of these things, great. And this is the first place where we should be looking. For some reason, people want to go and look immediately at issues of substance. And there's so much efficiency that we might find in our day-to-day lives from just quite basic amounts of training and support that's really human-centered. There's some sort of also familiar spaces around looking at the whole legal system now, not just the judiciary, around searching for cases, legal informatics, and so on. So we're physically in IALS right now. IALS, of course, the home founding home with UC Cork of Bailey, and legal informatics, free access to legal informatics, ability for just more advanced search engines that work better, that classify cases more richly, that can enable people to find and surface things, as well as other legal information, comparative law, all kinds of things that could be useful. Now, within these spaces, we've got lots of risks as well. We've talked about fake case citations and so on. Some of these issues can actually be dealt with technologically. They're kind of era of people having really fake citations is a sort of artifact of tools that exist right now. That's not to say the actual AI systems, the models themselves, are going to get magically better at that, but they're going to start to be more cautious. They will start to automatically be searching and referencing and finding whether cases are true. It'll become quite a complex software pipeline, but we should instead be looking, I think, at the way these systems might reshape our legal system. One thing we should be aware of is the way that modern software development works. And it's a bit of a risk. We're seeing that at the moment with a whole variety of legal technologies in the judiciary, including the sort of common platform world in England and Wales and in other countries as well. As modern software is developed, it's no longer software you buy off the shelf. Right? It used to go in the late 90s or early 2000s. You wanted to get a copy of Microsoft Windows, you'd go to a shop and it would be a comically large box, really wrapped up, and you'd have to take it off and install it, and it would be everything would be static until you went and bought a new one. But today, software is changing the whole time, and it's changing because it is the constant experimentation on the users of software. So there's surveillance and experimentation to understand, how's it working? Is it not working? How could it be improved? But it means that we're doing things on quite unstable and shifting sands. It also means that whenever people are deploying technologies, they're deploying them unfinished, incomplete, and they externalize all the risks and uncertainty of developing onto the users. Now, that's not great for the legal system because we quite like to get things right, and we quite like to get things to be done in a solid way with reliable tools rather than be working in a way where we're also all part of the experiment. Because there's big legitimacy problems if you do that. So in terms of software development, it's really hard because the modern software environment, Google, Facebook, they're all built on the lowest, most pathetically useless stakes in the world, ad tech. Who cares whether an advert does actually get delivered to me or not? The stakes are impossibly low. And that's how all modern software development has been shaped over the last few years. A world where experimentation is cheap, where getting things wrong, the cost can be borne by the user, and then we'll get it right the next time. It's not a great model for software development if we're thinking of something as high stakes as judging and dispute resolution. So we have to rethink about software development and not take lessons from big technology companies about this. And it requires really understanding the needs of people in the judiciary, needs of people in the legal system. So what actually is occupying my time? How could things be better for me? And to spend time physically with those people in those spaces, solving very human problems and focusing on those human problems first before we then move to what can this technology do for us? Actually, the solution might not be AI. Might be other forms of technology, other forms of computing, but let's start with the problems. Now, within that, we've got the bigger shifts, which I think the judicial technology needs to deal with. One, education. So I'm from this space, I'm from UCL up the road. We put out a paper quite recently, authored by myself, all the vice deans, and our dean on AI and educational technology, because we've moved almost everyone to secure handwritten exams in every context for this. And we're also focusing on foundational skills for development of legal thinking, critical thinking, because one thing we think is difficult, it's going to be hard to pick up and also maintain legal skills and critical thinking in a world of shortcuts and AI, especially when access to justice is more and more difficult. Legal budgets can then be cut even further because it seems like maybe you need fewer lawyers, maybe things can be done on the cheap and more research can be undertaken just by this machine and so on. More filings can be made and so on and so forth. Where's the pipeline of skills there? Who builds up that pipeline? Who is really in control? And do you get better at using an AI tool by using it? The research at the moment seems to show not. So in our legal system, it's not going to be the case that users of ChatGPT are better at ChatGPT because they use it more. In fact, people who are great at critical thinking, understanding the broader context, foundational knowledge, we're already seeing these people are better users of technology like this. But how do you acquire those skills today and maintain those skills in a world of shortcuts, rushing, optimization, and so on? And lastly, on this question, I just wanted to talk a bit about how judicial tools are going to have to navigate the broader effects of AI. we're seeing in both science and I think in courts now, looking at these recent cases from not just the case from Victoria Sharp, which was incisively written, but the broader databases online. There's a database of hallucinated legal cases tracking about 200 cases across many jurisdictions in the last year, cases about fake citations and so on. Writing is going to become cheap. Text is cheap. What does this do to our legal system? When you can effectively file huge reams of text, you can file huge amounts of nonsense, you can file just including parties with huge amounts of money can just deluge the other parties. What does this mean for how we actually do dispute resolution and judging? Do we then need to have an arms race of tools to help keep up with this? Is that actually the best way to go? Do we need to take a step back and say, actually, all pleadings should be this long and no longer? Do we do this for scientific literature as well? How do the judiciary deal with evidence that may be AI generated too, and scrutinizing method? They've always been pretty bad at getting involved with method and science, right? They've always been an area which has been challenging for the judiciary to cross that form of knowing from law into science and to do that challenge. And questions like the Horizon scandal just make that even more challenging. How do you get under the hood to work out if you can trust something? So navigating AI slop is going to become a really big problem, and work out how we reshape our judiciary so that these tools don't undermine it, as well as so people can use it in the right way.
Thank you so much, Michael. And just a short question. You mentioned several times that the trust and the tools should be reliable.
Yeah.
So how can fairness, accountability, transparency, and trust be ensured in the design, deployment, and use of artificial intelligence systems in judicial decision making?
Thanks. The one thing is that we have to think about the broader context of power in this. One is that we can't talk about tools being fair and legitimate without grappling with who is making them, who is steering them, who is making decisions around their design. And that's not just a case of who's making decisions today. It's about how do the infrastructures you install inside courts affect the way those courts are going to function over the coming decades. If you install one tech company's tools, are you going to be stuck with them? Are they going to have a disproportionate effect over that design and shaping of that? And how do you stay in control of that is going to be hard. And I think the danger we have, at the moment we have a lot of literature in research about fairness and bias. You can look this all up. These are issues that are being grappled with by scholars and engineers. How do you make a system so that when it looks at this, it's not going to judge someone based on the vernacular they use or based on some other feature, or it can transcribe people with different accents just as well as other people. Those are problems that are important to pay attention to, but they're not the trickiest problems in the world. I think for the purpose of the judiciary, the trickiest problem is dispute resolution should not be seen as an optimization problem. If we think about the way technology is built, it's often designed to optimize in a certain way, take a whole process and try and refine it for certain goals and certain aims. And if we think about what also big law firms do when they forum shop and when they look at how to best file and plead and which jurisdictions to use and if they choose their judge and all these kind of things, people already are at risk of treating dispute resolution like an optimization problem. In France, many people know there's been a sort of set of rules passed that limits the profiling possible of judges, judicial decisions, and so on. And I think there's actually some merit in this, insofar as we don't want, I think, judging to turn into some optimization-focused world. And in fact, what does that do for trust and legitimacy? Because as soon as we, I think, reduce it down to such sort of formalistic and really quantifiable aims, everything becomes quite brittle, and the very thick type of legitimacy that we try and achieve for many parties in society, I think, gets reduced. So I would urge people to look a bit away from some of the fairness, bias, discrimination, transparency literature, which is important, and instead think about power and just this logic of optimization. Is that appropriate for the rule of law, and how do we square that together?
Thank you so much. Thank you for such an enlightening and even eye-opening answers. And we will move now to a core specific topic on the Council of Europe's groundbreaking work on AI in courts, which began with the CEPAJ European Ethical Charter in 2018, and now includes the Framework Convention, which was mentioned already. And this year update was the first report on the use of artificial intelligence in the judicial system based on the information contained in the CPES Resource Center on Cyber Justice and AI. And this report was represented in February this year, as well as other report, how can artificial intelligence be put at the service of the judiciary? And this work would be not possible without the Artificial Intelligence Advisory Board of CPES. And luckily we have a speaker, another speaker. Marek, could you please describe your work on this advisory board and its perspectives in the future, please? Can you hear us well?
Yes, thank you, and good afternoon. So indeed, this ethical charter was a quite important document. We see that it is used by the member states in the implementation of artificial intelligence in the judiciary. But in fact, in IAP and in CPES, we are now in the phase that we can call an operationalization of the ethical charter. Quite a difficult terminology, I don't like it, but still it is about how to put these 5 principles from the ethical charter, like the principle under user control, into the practice in all 46 member states. So the very first thing that we did was the creation of the Resource Center on Cyber Justice and Artificial Intelligence. So to see the data, to collect the data, and to speak, to discuss real implementations of artificial intelligence in different states, focusing, of course, on Europe, but also checking the tools beyond the Europe. And thanks to that, the discussion is more practical, less academic, less theoretical, because we can check the real examples. So as already mentioned today, there are no robot judges. So this concept is false, you know, but I was just visiting we had some meetings in Paris, and I visited the legal libraries in Paris, Beqiraj, and I still see these books with the covers speaking about robo-juge, robo-judge, which is just misleading. It goes into the wrong direction. It is not evidenced by the data that we collected in this data center. And in fact, when we started this process 2 or 3 years ago in collecting this data, we assumed that maybe we will have the information about 20, 30 such tools. But now we have 140 tools that are already used in practice. Not generative artificial intelligence, but specialized tools that are also created by the judges, like, for example, the system Olga that was created in Germany. So my task today is simple, because I want to encourage you to check our website of the CPES and IAP, check the resource center, see the report from the resource center, see our other opinions, and maybe it will be useful also in your practice as well.
Thank you, Marek. And how many Council of Europe member states are currently involved in this work? I mean, how many countries participate in Resource Center? And what are the key insights of the first report? Could you highlight any countries, European countries, which are leading in the way of the digitalization?
Yeah, now it's we get a lot of examples and tools from Germany. France is very active in this regard. In fact, this second document that you quoted, the opinion how can artificial intelligence be put at the service of the judiciary. Originally, this was the opinion prepared in French for the Cour de Cassation in France. Due to their interest and the developments in artificial intelligence, but it is the original document was of such high value that we decided to translate it also to English, to update it and to make it more general for the member states. Because this is what we do. We support the member states. Also, the resource center was created because of the request of the member states that they want to see how these tools are used in other countries, just not to reinvent the wheel, but to really see the real experiences. So we have what we call a cyber justice network. We organize also webinars. Tomorrow we will have a webinar on the digital case management. So every quarter there is something new. And I can say that all member states are represented, 46 member states. Also, the invited people come from other countries. We participate in the meetings of the World Bank Group. I think that this week we will have another meeting, and we also collect interesting uses of AI from Brazil. Brazil is a very interesting country that judges are using a lot of such tools. The same Colombia, when this is a mandatory obligation for the lawyers, also for the judges to use the most technological advanced tools. So of course you are also invited to join us in these efforts.
Thank you so much for your kind invitation. And talking about your native country, about Poland, being a university professor in Poland, how would you assess the current outlook and prospects for the digitalization of the judiciary in your country?
I was positively surprised that in the revised new version of the strategy for artificial intelligence in Poland, there is a whole chapter about AI judiciary, artificial intelligence in the judiciary, and two examples are mentioned that are very typical. First is the chatbot to that citizens can ask their legal questions, can get some support from a chatbot. But this is not, of course, ChatGPT, but this is more specialized tools that is under the control and the data is secured. And the second tool is an assistant for the judge. So these are two typical examples of the implementations of the artificial intelligence. But still, well, in Poland we have other problems regarding the judiciary. You may be aware of it. So artificial intelligence is still not the very most important topic.
Thank you so much. Thank you for your answers, comprehensive answers, and I suppose they will provoke questions from the audience in a while. And now let me give the floor to the last speaker. I'm very pleased that my former colleague, with whom we had been working in the same chamber, Grand Chamber of the Supreme Court for 3 years, made this long trip and visited us. So the floor is yours, Judge Janowska, please. Could you could you please share with us the current stage of digitalization of justice in Ukraine and how it has been affected by the COVID pandemic and the wartime? I thought the question is obvious. Excuse me.
Yeah. This is the first question.
Yes.
Yeah. First of all, I want to express my deeply gratitude to the Institute and especially to you, Tetyana, for your invitation. And I'm very happy to see you and our inspirer and organizer of our judicial reform 2016 in Ukraine, Sergei Kozyakov. Your institute, you are lucky, and and the Supreme Court of Ukraine has a great loss on behalf of Tetyana, because really we need such high professionals. What about pandemic and war? Certainly, the digitalization of Ukraine has accelerated due to pandemic, COVID-19 pandemic. But as Russia's war against Ukraine has badly affected the operation of whole Ukrainian judicial system, and ongoing hostilities and damaged the court buildings and displaced the population. The lack of personnel and electricity caused by Russia's attacks on energy infrastructure certainly disrupted court work. Yet, despite these tragic circumstances, the vast majority of judges and court staff performed their duties. And on this note, I would like to express my heartfelt gratitude to Britain, to its people, for all the European community, for your unwavering support of Ukraine and Stefan's leadership in support of Ukraine during the most difficult days and nights of this unfortunately endless war. And what about digitalization? After years of discussing the atrocities of war, really it brings me great joy to highlight the progress of Ukrainian judiciary in assistive IT technologies. And certainly several digital solutions have been implemented. And one of them is established of the Unified Judiciary Information Telecommunication System, UJITS. It is a set of information and telecommunication subsystems that provides the processes within the judiciary. Let me very briefly describe each of these subsystems, because in 2021, 3 UJIT subsystems began functioning. The first one is electronic cabinet, which is a secure web service that provides with official internet address, which provides the processes for the registering users, as well as further authorizing such persons to access them into UJIT's subsystems within limits of rights granted. The second subsystem is electronic court, e-court, that enables exchange of documents, particularly procedural documents, written and electronic evidence between the court and trial participants, as well as receiving the results of the consideration of such documents. And the third one subsystem is a video conferencing subsystem that provides video and audio recording, reserves courtrooms, as well as enables submitting the documents by the parties during the court hearings via video conference, so on. And I want to say that, unfortunately, we have to remember that Russia is waging a hybrid war against Ukraine. And due to the targeted large scale cyber attack on the computer services and automated systems of the Supreme Court. These systems has been suspended from 6th of June. But the last information is that some of them are fixed, but we have a big problem with this cyber attack. And I want to note that I think that all European countries have to remember that and to be prepared for such hybrid cyber attacks. And as returning to the impact of the war on the judicial system, I have to say that despite missile strikes, air raids every day in Ukraine, judges enter courtrooms and deliver justice. In 2024, Ukrainian courts considered more than 4 million cases.
Impressive. Thank you, Alexandra. And what about pre-trial stage? Because from the open sources, we can find an information which general prosecutors offers regularly updates about over 150,000 registered criminal proceedings. Are there any innovative AI tools used for electronic document exchange in criminal proceedings? Because obviously it's impossible. It's very huge amount of work to do it manually.
You're absolutely right, Tetyana, because it is really a great issue, taking into account really a tremendous sheer amount of the registered war crimes. Now, currently it is 170,000 crimes. And taking this into account, I want to draw your particular attention on one more very interesting and significant achievement of Ukrainian digitalization of the judiciary on the pre-trial station, the e-case system, which is essential part of Ukrainian judicial transformation. The e-case facilitates the gradual shift to the electronic digital documents during pre-trial stage. And now, however, it involves only National Anti-Corruption Bureau of Ukraine, Specialized Anti-Corruption Prosecutor's Office, and High Anti-Corruption Court of Ukraine. The purpose of e-case is to automate the pre-trial investigation from the creating and storing documents and to transforming and of information between detectives, prosecutors, and court. And I want to say that in 2023, the High Anti-Corruption Court of Ukraine implemented the case system, eliminating the needs for court staff to convert documents into paper form. And now most court cases are maintained digitally. A little about numbers. As of April 2024, more than 1,700 criminal proceedings have been entered into system. The system also allows for generating the procedural documents into 67 template forms. Certainly significantly saving times in exchange between detectives, prosecutors, and court. In 2025, the National Anti-Corruption Bureau of Ukraine and the Specialized Anti-Corruption Prosecutor's Office filed more than 730 motions with the High Anti-Corruption Court using the e-case system. The trend of active use of this system remains high. It can be seen if we compare the number of applications for search warrants filed with and without the system. For almost 80% of the total number of such motions filed through the system into the High Anti-Corruption Court. However, the statistics on application for temporary access are relatively low. Only 60% of such motions from the total number filed through the system. I want to say that today the possibility of completing the entire circle of a digital court case exists, creating a petition in the e-case system, submitting it to High Anti-Corruption Court, receiving the documents by defense party in the electronic court system within user's account, reviewing it certainly, submitting documents by the defense party, as well as filing an appeal. And all these stages can take place exclusively in digital form. In summary, it is important to note that conducting an effective pretrial investigation is deemed impossible without functioning of information and telecommunication system, which is already legally been implemented. However, it has yet to be implemented in the operations of all pretrial investigation bodies.
Thank you, Alexandra. And we can assume that the Ukrainian judicial system has made significant developments for the last 5 years related to generative AI technologies. If there are any you didn't mention yet.
Yeah. Thank you for this question, Tetyana. You know, all achievements of Ukraine in the digitalization of justice are very early step, certainly, but they are meaningful. And in this regard, I want to highlight really one more significant achievement related to AI technologies. First of all, I want to point out that in 2024, the Supreme Court reviewed nearly 90,000 cases. This enormous workload, you know, this enormous workload certainly requires skilled professionals and robust software tools. And one of such tools is the legal position database. This is not just a research tool. This is a tool that ensures the unity of the judicial practices. It stores the legal positions taken by the Supreme Court in different cases. This certainly facilitates the maintenance of certainty, consistency, consistency and predictability of judicial decisions. In the past, legal professionals had to search manually through large, often unstructured databases. This process certainly was very slow and inefficient. Now, today, with the legal position database, the relevant case law from both the Supreme Court and the European Court of Human Rights can be accessed quickly and allows lawyers assess case outcomes with greater certainty. Let me very briefly outline some of databases. Okay, very quickly. I only highlights that the key function of this database is a full text search. So you can take the full text of the decision or of some Word document, paste it into the search slot, and then you the database returns the relevant position of the Supreme Court. And one more interesting feature is that you can search with the link to the court decision register. You may know that in Ukraine, the Unified State Register of Court Decisions has been operating since 2006. It contains all decisions of Ukrainian courts in anonymized form. And this anonymization is also performed utilizing AI. I finished because I understand that we have no time.
Thank you so
Thank you.
much. Thank you. And the shocking news you shared with us about the hackers attack shows how fragile any progress or any system can be in the face of aggression or simply destructive attack. So obviously the preconditions for sustainable development and any progress are peace and cooperation in the world, which we shouldn't take for granted. And dear audience, I think now we can open the questions and answers session. And please don't forget to state your name and affiliation and to whom your question is addressed. Can I invite 2 or 3 questions, please, from the room? Thank you.
Thank you very much. Thank you. Richard Wolski, Cambridge University. I've been involved with AI for 35 plus years. And probably one of my main areas of interest and concern is sound reasoning within AI systems. Now, as much as I can talk about this, but I'm particularly interested in the idea of legal arguments and how modal logic, probabilistic reasoning, and so forth could help enhance the way things in court cases.
You're saying probabilistic reasoning.
Probabilistic reasoning,
Yeah.
modal logic.
Yeah.
Yes.
Was it the question for
No,
Michael?
for Michael.
Yes, okay. And another 2, I think we can take another 2 questions and then give the floor to our speakers.
Thank you. Hello, my name's Greg Falkov. I'm from Mishcon de Reya, a law firm in London. A question for Michael and perhaps also for Lord Neuberger, which is a question as to whether you've actually seen in practice judges or other judicial decision makers using AI tools. And if you have, how do they use them?
Hi, Katie Lyons from the Bingham Centre for the Rule of Law. I have a question for Marek on the database of AI tools in the judiciary. Did you also collect qualitative analysis about how far the users of those tools found them useful and what the impact was on issues like the rule of law, access to justice, fair trial rights?
Thank you. We have 1 more question. Okay. 2 more questions.
Hi, I'm Sarah Razai from the British Institute of International Comparative Law. I think my question is also directed to Dr. Veal. I really would like you to develop a little bit about the optimization issue and maybe just how would that relate to questions of legitimacy of the law moving forward? Thank you.
Thank you. And the last question from the first row, please, and it will be all.
Thank you. My name is Dora, and I'm a recent graduate in AI and law, and starting my PhD soon in law and AI as well. I got my first question is just a clarification question, really. Firstly, on what the definition is of AI models, on the patterns of that, and how we are defining it. And secondly, my second question is for Dr. Veal and Lord Neuberger as well. How is the legal system in the UK starting to look at long-term protections in the legal systems for the vulnerable? Thank you.
Thank you so much. So probably we will give the floor to Michael first, if you are.
So yeah, thanks.
If you
yeah.
yes, maybe you can summarize some of the questions and just to give the general.
Yeah, exactly. People
Yes.
can approach afterwards if they
Yes.
want sort of
Yes,
more
of course.
details. They won't take all that time. Different kinds of reasoning and contemporary AI systems, particularly, I think the interest in generative AI systems powered by transformer models. Really, we don't know how these things reason. With the reasoning traces they give don't actually mechanistically resemble what is happening on the outputs. If you ask a model like GPT-4 or similar to explain why it just did something, well, that explanation is not real. It's just more prediction of text one token at a time. The concepts that are used within the model are triggered by multiple different words in a sort of compression way. It doesn't actually bear a resemblance. We can't pick it apart very easily and understand what's going on. And I think this makes it very difficult to piece apart why systems answer one kind of thing instead of another. Most of the things we know about these models are based on benchmarks of just how they perform when they have tried on different databases of massively varying quality, with very little meaningful stakeholder and domain expertise involved in the design of these benchmarks. And so we don't really know very much. One of my PhD students, Anton Garmoza, is finishing, he's about 3/4 of the way, maybe 2/3 of the way through his PhD on language models and analogical reasoning in these systems. And how much can we think of these systems as engaging in analogical reasoning, looking for analogies? An interesting thing is we can't really look at use the information inside the model. So people ask models, it goes to the question of what is an AI model here? There's different layers. There's a model itself, the actual model with weights, the neural network kind of style of things. And for these newer generative models, that encodes knowledge. It's almost like a compressed set of knowledge, but it also produces things that look spurious and are spurious and look plausible. So it's not very good. That's why we get the fake citations that Victoria Sharp was referring to in her judgment. And so these systems are often coupled with systems called RAGs, retrieval augmented generation, which is basically more or less just the model itself doing a Google search and then taking the results of the Google search and rejigging that and giving it back to you. And the quality of that depends on the quality of normal legal databases. So you need a well-organized tagged legal database to make the most of any of these things. And then you've just got a more powerful guide trying to find and surface some of these things. So I think instead of asking the model to go the whole way and think about what is the reasoning, we just need better search tools to bring things into the view of humans and stop there to some degree. And I think that helps us with some of those issues. And then I'll say on the optimization point, to elaborate a bit on that, I mean, we see a lot of this in search engine optimization, right? How people try and get their website at the top of Google. It's treating a system like you can game it, basically. And when people use tools that are more deterministic and end up with certain decisions in certain situations, then we will have a kind of counter set of tools that will be designed to game those tools. We have big issues here of, I mean, in law, we would call this equality of arms, right? Where to say, will a big legal firm have access to big, expensive tools that will help them understand and win a case compared to a small provider? And what does that look like? And I don't think that really is the battleground that we want the rule of law to be based on. And lastly, just on the legal protections in the UK that are emerging. Firstly, we don't know, the UK is heavily delaying any kind of regulation of AI because it's being held hostage by the technology companies who are promising data center investments. These are real estate investments that will build about 20 or 30 jobs in the whole of the UK. Have you ever seen a data center? Maybe they'll provide some catering and some with a mop and a drain on power in a country that notoriously has extremely high energy prices. And in return, they are being held hostage and being asked not to regulate anything at all, let alone the copy, say, the EU's AI Act, which is quite a weak piece of regulation based on product safety. And the main focus, I just want to flag this because people in the room will understand it, but it's not broadly understood. One of the main things the AI Act does is it is a maximum harmonization instrument that prevents member states from regulating in any area that the AI Act has not touched but concerns AI systems. It preempts huge amounts of national law And it is a gigantic loss because we need policy experimentation here to work out what really works. And so we've got a big issue there with those instruments, and we're not seeing that in the UK.
Thank you, Michael. Thank you. Lord Neuberger, would you like to add anything or later?
Happy to do so now or later.
Okay, okay. Yes.
I'm going to say, so far as vulnerable people are concerned, when we had IT introduced at a very basic level in terms of registering claims and documents in court on the internet, the Ministry of Justice struggled to help people with vulnerable people, because on the one hand, it offered a wonderful opportunity for efficiency. On the other hand, if you have a significant number of vulnerable people, you need also to carry on a normal analog world so that they can be helped as well. There was further problem in that efficiency led to fewer and fewer courts and more concentration of bigger courts in areas, because everything moves so slowly in this country. It hasn't happened much, but that was the aim. And that means that vulnerable people are also affected because they'd have to travel more, and they're the ones who are most affected. So the answer is vague attempts are being done, but nothing very substantial. So far as judges' use of AI is concerned, one of the perennial problems in this country, and it applies to the judiciary, to the legal profession, the civil service, to politics, is the generally low appreciation and understanding of science. And there are very few judges who are comfortable with scientific ideas, let alone with technology. And the judges who are most used to this and most valuable in this area tend to be the judges who specialize in patent law, because many of them have serious science qualifications, and if they don't have them, they have experience of scientific cases, because patents increasingly involve complex science questions. And probably the leading expert in England is Lord Justice Birth in the Court of Appeal. And picking up one question, as you probably know, he has actually written a judgment where he said the next paragraph, or maybe the last paragraph of this judgment that I've just written, was written by AI, and he shows what it can do. Generally speaking, the Master of the Rolls in particular, Geoffrey Voss, is very keen to warn people about the use of IT generally and how important that is, but warning them against the risks of AI. And I think on the whole, the general view of the judges is rather nervous, because first of all, the law moves slowly and AI develops quickly. So coping with it is quite difficult. And secondly, as has been said, the law depends on accuracy. And at the moment, AI is not reliable in terms of accuracy. One final point. It always interested me that people are very concerned about how AI works and talk about it being a black box and how we don't actually know how it reaches its decisions. Sometimes as a judge and now an arbitrator, I think of my own brain as something of a black box and we don't quite know how it works, because very often I think many judges, and I fear sometimes me, have an instinctive reaction as to what the right answer is, but then jog backwards to try and retrofit reasons to justify our conclusions. And maybe that's not that different from AI. I don't know. Thank you.
Thank you so much, dear David, for such a thoughtful and brilliant comment. Thank you. And Marek, are you ready to answer the question?
Yes, I'm ready. So we don't do it in the resource center itself, because the resource center is an open database that you can access on the internet. You can check the tools. It is a passive, in a sense that we don't measure the impact of specific tools. However, we want to use some data from the resource center, like also the categories that of the AI tools used in judiciary that we invented for resource center, and now these categories are used also by other committees in Council of Europe. And 1 week ago, during the meeting in Paris, we discussed this new tool, this new project focused on measuring the impact of such tools on access to the courts, on efficiency of the legal system due to use of the new technologies, because this is exactly the job for CEPES. CEPES is collecting the data, and for start we will use some simple questionnaire with numbers from 0 to 3 to measure the impact of the different tools in different countries, and I hope the results will be available soon. In parallel, please remember that every year CEPES is collecting the data from member states, is preparing the statistics and so on. And recently we also extended the part of the questionnaire for the member states regarding the use of artificial intelligence, and there are specific questions that can be also used to analyze, to assess the impact of such tools in a given countries. So check our websites.
Thank you so much. So as moderator, I should admit perfect timing. Just 2 minutes before finish, and I would like to thank everyone for joining us today. And first of all, Lord David Neuberger for making time to join us, and our distinguished speakers, and our distinguished audience, and those who made this event happen, our incredible events team, and who put so much efforts to organize this event. So thank you so much. Thank you, BICL Director Spiros Maniatis and Jan Smit for your support and your invaluable contribution. Thank you so much. Thank you.